Let's keep that magnifying glass put up. Okay? Done. Great day. Great day.
I know.
Ain't nothing to me. All we here. If y'all will, please take your seats. And join Randy and I in putting our phones on silent.
All right, good morning, ladies and gentlemen. Let's just go ahead and get started this morning. We got a couple of members that'll be coming in. Now we've got looks like a quorum with Senator Elliott. We're going to move around a little bit. First bill on the agenda is my bill that I'm carrying. Let's come back to that. I think some folks maybe give them time to get here as well. Second bill on the calendar, if I'm not mistaken, Holly, is that correct? It's Senator Weaver's bill, and there's a public hearing on. So before we jump into the public hearing, Ms. Ogden, if you'll call the roll for us.
Senator Albritton. Senator Bell.
Here.
Senator Carnley. Senator Coleman Madison. Senator Elliott. Senator Figures. Senator Gavan. Senator Orr. Senator Singleton. Senator Smitherman. Senator Stutz. Senator Weaver.
Here.
Senator Barfoot.
Here.
And we have a quorum.
All right, we've got a quorum. All right, Senator Weaver, your bill SB 293. If you want to tell us about that, and then we'll jump into the public hearing. Members, just so you'll know, since there's a public hearing call today, we won't be voting on this bill. We'll just take up the public hearing and go from there. Senator Weaver.
Thank you, Mr. Chairman. This bill is the First Responder Interference Act, and it just says if a first responder, which is defined as a law enforcement officer, a firefighter, or EMS personnel, if they are in their role as a first responder doing their duty and a person approaches or remains in 25 feet of them or tries to impede or threaten or otherwise harass them after being instructed not to, it would be a Class A misdemeanor. Happy to answer any questions.
Thank you, Senator Weaver. All right, let's go ahead and get started with the public hearing. We've got a couple of folks that have signed up. We've got 2 proponents and 1 opponent, and we're going to do it this way. We're going to limit it, unfortunately, with time restraints we have, to 2 minutes for each. Ms. Ogden will have a timer. You should hear that buzzer go off, and once you hear that, I'd appreciate you shutting it down. 1 or 2 words to finish a sentence, but appreciate it if you just shut it down then. First up, Eric Penley, and when I call you up, if you could just make sure that you address the committee and let us know who you're from, who you represent, and why you're here. Thank you, Mr. Penley.
Thank you, Mr. Chairman. Thank you, committee. I'm Eric Penley, the president of Alabama Ambulance Association. Thank you, Senator Weaver. We fully support this bill. I think it's not only a safety issue for us, it's also a safety concern for patient care. We get distracted sometimes. Emotions when you're on these scenes sometimes can get out of hand, and not intently to start with, but it can lead up to that. And so, there's only one first responder that I guess has the authority sometimes to get people away, and a lot of times you only have EMS guys, paramedics, and firefighters there, and we're not respected at times just to ask people just to back up, and police is not always there. But definitely this is something that we need. I feel like it's a public safety issue. I feel like it's a safety issue for our first responders. I also think it's a patient care issue. People start getting closer and we ask them to step back and they don't, then it become a distraction. We may push the wrong medication, may miss something that we need to do for patient care. So I think it's definitely a public safety issue. And I want to thank Senator Weaver for bringing this. And I also spoke with the Joint Fire Council this morning, Chief Lords. They couldn't be here, but they fully support this as well. So the fire and EMS support this bill. We thank you, Senator Weaver. Any questions?
You're welcome to. You're welcome to. And Senator, I don't know if you came in a little bit after I said, but just a public hearing today. We're not going to vote on the bill itself. We may have some amendments that we want to discuss or debate. We'll get to that in a second, maybe, potentially. But glad to ask you any questions. Now would be the time.
Thank you. I just want to ask you, in a situation where, and I'm just going to kind of paint a situation. I know y'all done seen so many of these, what I'm saying, that is unreal. You got a child out there. Something happened. Mama drive up. Mama ain't gonna be calm like that. She ain't gonna be calm. We can pass that bill all we want to. Mama gonna go on to go see her child. When, like you say, you bring it on the stretcher, you take it. Mama gonna want to run up there and somewhere see the child. What exceptions is for mama? I think, because that's gonna happen. Next thing you know, you're gonna snatch mama, throw her in jail. Her son, now I don't mean you, but I'm just saying that we pass, we're going to throw mama in jail. You trying to do what you trying to do for the child. So you got the child out there messed up because y'all trying to take care of him. Now you got mama over there. Can't even go see him when he go to the hospital or wherever you take him because mama going to jail, based on this bill right here. So I realize what you are saying about getting these folks out the way because, you have slow people driving by, want to stop, get in your way, and everything else. I know what you're saying, but I agree with that. But in every rule, that most of the time there's an exception. And what can we do about mama in this situation right here?
And I think we want mama there because, number one, mom's going to make the decisions for that child, right? And I think we have to ask them to step away first, where I think this is a violation, and I believe that's correct. And I don't think we're going to ask mama to step away. We need mama to go with us because she's going to help with the child. So,
okay. Senator Weaver.
Thank you.
And certainly, Senator Smithman, we're not going to vote today, but I'll work with you to make sure because as mama, I want that too.
All right. Thank you, Mr. Penley.
Thank you.
Next up, we have Camille Bennett, who's an opponent of the bill. Ms. Bennett, if you'll come up and identify yourself to the committee.
Hello, my name is Camille Bennett. I'm with Project Say Something. I'm from Florence, Alabama. SB 293 can violate the rights of protesters and citizens in the following ways. If protesters cannot hear the instruction to vacate the premises and people are still less than 25 feet away from the officer, how can the first responder accurately measure 25 feet in real time? Will first responders carry sound amplification devices instructing protesters to stand back? What happens if not everyone hears the instructions? Will multiple people be charged with a misdemeanor? That can carry up to 1 year of jail time. SB 293 has the power to eliminate third-party recordings of crime scenes. The recordings of police incidents have been proven to contradict the reports of the officers involved. This bill will eliminate that window of accountability. Citizens may feel intimidated when witnessing police brutality based on the 25-foot rule, which is an arbitrary number left up to the discretion of the officer. If a person is experiencing a mental health crisis at a potential crime scene or governmental function, their impairment may and inability to interpret the language may lead to an unwarranted punishment. If someone has a disability that impairs or severely limits their ability to interpret a command to leave an area and create an arbitrary amount of space between themselves and the public service, will they be punished? If the intent of SB 293 is to protect first responders in the line of duty, the law already exists. Why do we have more vague and restrictive language? If SB 293 was meant to expand the current code to protect public service, their protection cannot disregard the First Amendment rights of the citizen. Thank you.
Thank you, Ms. Bennett. All right, next up we have Hossback. Sheriff, you're here. Glad to have you in committee. If you could come up and identify yourself and who you're with.
Good morning, Mr. Chairman and Senators. Huey Hossmack with the Alabama Sheriff's Association. We are in support of this bill. I think it's a piece of good legislation. Particularly, it is very timely in the world that we live in today. I think a few little things that I do want to point out on this is, number one, there is a requirement for an initial notice for the person to get out of that area or to retreat from within the 25-foot circle. 39 years ago, when I went through the Alabama Law Enforcement Police Academy, and is still being taught today, there's what's known as the 16-foot rule. And the 16-foot rule is that a person with a sharp-edged weapon can react within 1 to 3 seconds and cause you physical body harm from 16 feet. The tiles above your head are 2 by 2. If you count those tiles, this is 25 feet. I think everybody in this room can hear me. Everybody in this room can see me. 25 feet is not an unreasonable distance for officer safety and all of our first responders. One of the things I'd also like to add is with any particular law, there's common sense and discretionary that it applies to this. I agree with Senator Weaver, Senator Smitherman. I don't think we want to see any person that is a relative, that is a mother or a father, that would like to be with that person there. I think that's where that comes in. But I think it's very important on line 35 down through 40 that we're talking about a person who impedes, a person who threatens, and a person who strikes. So we're talking about direct interference with a lawful action and trying to prevent things from getting out of hand. You only have to go on any daytime news in the world we live in today and see in just a click of a moment, it can get out of hand. This will provide the law enforcement officers and our public safety personnel the afforded protection that they need, that they can continue to do the job that you ask them to do every day.
Thank you, Sheriff. Appreciate you being here. All right, members, what we're going to do is, Ms. Weaver, Senator Weaver.
So I know we're not going to vote today, but I would like to adopt the amendment. I've been working with the Press Association, and we've reached an agreement with an amendment to address that
Members, that should be in your packet.
First Amendment right. And it should be in your packet, and it just says that it does not apply to news gathering activities from bona fide news organizations, and we are not trying to impede or interfere with them collecting the information for news or interviews or documentaries or on-the-spot coverage of news events.
Senator Smithman. A motion for favorable and
Second.
Senator Smithman, second by Senator Elliott.
And a comment, if I can, Mr.
Sure.
Chairman. Thank you for defining a bona fide news organization.
Thank you. All right, we've got a first and a second. Any discussion on the amendment? Hearing none, Ms. Ogden, if you'll call the roll on that.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton? Senator Smitherman? Senator Stutz? Senator Weaver? Senator Barfoot?
Aye. All right, the amendment is adopted, and we will look forward to having that bill back in committee as amended. Thank you, Senator Weaver. All right, now we're going to go back up the list to SB 336, and members, I apologize. I picked up the wrong folder along the way and had some handwritten notes here, but I just want to make sure you understand this is an important piece of legislation that we brought last year. This will be the second year, I believe, in a row that we've had it. Obviously, we're somewhat time constrained. I'm asking this committee to get me out of today. Yes, sir. Motion for favorable and a second on the Paris Hilton Child Safety and Accountability Act. Any opposition to using previous rule? Hearing none, the bill is given favorable report. Thank you. And I'd urge the members, we've got some folks here that would like to come around during the day and talk to you and tell you about their experiences. You've gotten, I think, an email that I sent regarding, or Ms. Ogden sent, a video that Ms. Paris Hilton did in support of this piece of legislation. So I would appreciate if you'd spend some time with those folks who are here, and you'll be seeing them throughout the day. Thank you, committee. Next up, SB 43, and so Senator Coleman's not here. She had worked on this piece of legislation for a while. I'm sure you've all heard from her. She is very good. We got a first and a second. Any discussion?
One comment, if I may, Mr.
Senator Albritton.
I've got some serious issues with this, but I'm not making an issue of it today. But if we get to the floor, whenever we need to have some discussions on it.
Understand. All right, members, hear no more discussion about that.
No.
Opposition using.
More than serious discussion.
Well,
We don't have a lot of them.
so previous roll with Senator Albritton, Senator Gavan as a no on there. Any opposition? Hearing none. That constitutional amendment is given a favorable report at the time.
Mr. Chairman, can I just ask one question?
Sure.
Does this not just set up a mechanism to do, this is does not actually
Leaves the barn door wide open.
No.
well, I mean, you have to set up a law to enable I guess it set up the enabling legislation, correct? Is that correct? I read it.
That's right. The Constitution forbids any retroactive treatment of statutes. I understand extremely valid concerns on both sides of the equation regarding any potential legislation that would occur that we'd be talking about. I understand, the rights of folks who have been abused and violated and the serious nature of that. There's also a balancing act there of whether or not any potential legislation in the future would mean that it would be retroactive to a point where you lost witnesses, lost evidence in the way that makes it very difficult for individuals or defendants, be it entities, to defend themselves against claims. And so it's a valid point on both sides. I just think we moved the constitutional amendment out of committee today and have it for continued discussion. Senator Smitherman.
I don't know what you got in mind yet. I do want to say this though, that as you look at it, because I haven't had a chance to look at what I'm getting ready to say yet, but there may be something that's necessary also as it relates to frivolous claims. If you're going to have a situation that you're going to go back so many years, somebody could just all of a sudden get mad and just say, well, I'm going to do A, B, C, or D. You get a divorce and they say, yeah, you remember 25 years ago, I didn't like A, B, C, or D, so now I just think that if we're going to look at that end, you still got to make sure that the people who come in right is going to come in for a right reason. So as y'all work through that, just consider that part.
Thanks, Senator Smitherman. All right, next up, HB 420, Representative Butler. Welcome back to Senate Judiciary.
Thank you, Mr. Chairman and Senators. I appreciate you letting me come before you today. HB 420 came about. My nephew works for the DA's office in Etowah County, and in researching a case, he called me to tell me, he said, did you know it is a lesser crime to discharge a firearm into an occupied school bus or building than it is an occupied car? So this literally changes it from a Class B to a Class A, and we're removing the exemption for those under 19. But it's that simple in a nutshell.
Thank you. Got a motion for favorable, Senator Bell, second by Senator Gavan. Any discussion on that, Senator Smitherman?
I just want to be clear now. What you said this bill do?
Yes, sir. It changes it from a Class B to a Class A felony.
Change what to that?
I'm sorry?
What are we changing?
If you discharge a firearm into an occupied school bus or school building,
Oh, I see what you're trying to do.
currently it is a Class B, but if you discharge a firearm into an occupied vehicle, it's a Class A. We're just bringing it up to the same.
Into a school or a school bus?
Yes, sir.
You should say a Class A plus for the school bus. Because I'm
sir.
for you for that. That's all I wanted to know.
All right, any opposition to your previous role, Senator Gavan, you'd like to be added as a yes? Hearing none, bill's given favorable report. Thank you.
Thank you very much.
Here this morning. All right, one of my favorite House members, HB 60, Representative Tillman. No, this time I mean it.
I hope so. Thank you, Mr. Chair. Committee members, good morning. HB 60 is a bill that deals with continuing court cases for active military members who are attorneys and or indispensable, or we call material witnesses to a case. So if an attorney is an active military member and they receive orders to leave or they won't no longer be available, then the court can continue those cases.
Mr. Chairman, I'll second it and just could I recognize?
Yes, we got a first by Senator Coleman Madison, second by Senator Smitherman.
You just bring it in line with let's see, you, look around, you, me, because that's what the courts have to do for us now, because we down here.
Absolutely.
That's exactly what they do. I mean, the judge said the Constitution said that the legislature can seize us. That's what the judge says. We'll come up there and pick us up out of court and bring us back down here. So you're just getting in line with that, and I think that that's good.
Thank you, Senator. Thank you.
Thank you. Any opposition using previous role? Hearing none, bill's given favorable report. Thank you. And we've got to twist our mutual friend Virgil Ford's arm. We need to get him up here and show what real lawyers do at the State House rather than
Absolutely,
the
I
courthouse.
agree. And make them pay for lunch.
That's it.
Thank you, committee.
Thank you. All right, next up, HB 188, Representative Baker. Good morning.
Good morning, Mr. Chairman, members of the committee. HB 188 is the identical bill that passed this committee last year. This involves terrorist threat. This removes the language that it would be must be proven that it's credible and imminent for charges to be brought forth. It does not change this would be for a terrorist threat in the second degree. It does not change the charge. It would still be a misdemeanor, but if there should be a second or subsequent conviction, then this would elevate that to a Class D felony.
Move for favorable. Senator
Second.
Smitherman seconds, and he's recognized for discussion.
I appreciate what you're doing. This body several years ago helped me pass, I don't know if it was our first terrorist threat bill. And it's because, I represent those synagogues over on the edge of Birmingham, Mountain Brook, over in that area. That's in my district. And back when we had those several years ago, they asked for something to be done. And you've upgraded this. What I would ask you to do, if you would, if you probably already have, but if you would get with Senator Woods, because he has a terrorist threat bill, and I think that you all may be working together now.
We have been in collaboration. Thank you so much.
So that it'll be in line with what he's trying to do as well, because he's kind of talked to me already about that, and I like what he's trying to do. So if you you know, if y'all will, so when it hits the floor, you know, we'll be, well, it's you or he or whatever way y'all do it, we'll be ready to roll, okay?
Sounds very good. Thank you so much.
All right, members, we got a first and a second. Any opposition using previous roll on this? Any further discussion, I should say, and then any opposition using previous roll? Hearing none on either. Bill's given favorable report. Thank you for being
Thank you,
here.
Mr. Chairman, members of the committee.
All right, HB 106, Representative Givens. Welcome back to Senate Judiciary.
Thank you, Mr. Chairman, committee members. 106 is the companion bill to Senator Figure's Bill 203. It's doxing. A person commits a crime of doxing if she intentionally shares someone's or their family's information, address, anything online that can cause harm to this individual. It updates the Alabama law. Before, the Alabama law was before all the social media where you had the online threats and stuff. So this is just updating existing law.
I have a question.
Senator Smith.
How are we going to determine intentionally? I mean, I put something on right now, and I said that I had no intent to do that, whatever it is that you're trying to stop. How are you going to prove that yes, you do have intent?
That would be up to the law enforcement to prove that. Probably there's an ongoing battle, I would think, but if you're just putting something on social media and mean nothing by it, there's not going to be a problem. But if you're intentionally trying to harm, and I know you're saying, how do you prove you're intentionally trying to harm? That would be up to law enforcement.
So let me just tell you why I said that, and I'm being, as honest as I can be with you on this. It's because if we're leaving it, and you all correct me, wouldn't that be subjective? Not objective, subjective. If we're leaving it to the subjectiveness of in that case, you said law enforcement, then I'm just here to make a major announcement to you. I ain't gonna get no benefit of the doubt. It ain't gonna happen. I don't have to go into why. Everybody in here, they smart enough to know what I mean. It ain't gonna happen. So how are we going to prove it? That's the problem that I see right here. I agree with what you're trying to do, and that is not somebody throwing some stuff on there trying to mess over people and, intentionally do that and show them a false light. I understand what you're trying to do, but the standards, it's got to be tighter standards than just subjected to an officer walking in and they decide that's what it is. And then an officer talking to the person, they say, no, I didn't. I had no intent to do that, A, B, C, or D. I might have been they might have been highlighting the issue. They happen to be this person who carrying the issue instead of trying to hurt them personally. So that's where your problem coming in with this is that's got to be tighter defined as to the, like a better word, the elements of the crime. We've got to have some elements on there and got to have some be able to touch A, B, C, or D, So that's what I would, I don't know the answer to it, but that's what I would ask you, whoever you're working with, to try to do something with that, because the way it's kind of standing now, it's just wide open. Anything that show up and somebody say, I don't like that, and I'm going down here to press charges. I mean, prima facie is on there. So now, the first thing I'm saying, if they put it on there, it must have the intent to hurt somebody. And that's, making a negative light, and that's a little too open, and leaves too much objectivity to, someone to do that, So that's my concern.
It's Senator Gavan, then Senator Bell, and then I've got a comment on that.
Thank you, Mr. Chairman. So I'm on the study committee with the Uniform Law Commission, and this is a challenge for this issue, the challenge on how to handle it, how to balance First Amendment rights, how to deal with it from a criminal perspective. And I think I appreciate you bringing this and advancing the discussion. I'm going to support the bill, certainly in the committee today. I think to address what the senator brought up, the way we communicate with people is they don't need to know what our, and I think Senator Figures would be the first to agree with this. Not that I'm usually bold enough to speak for her, but, knowing what our addresses are, for instance. I mean, do you expect somebody to come knock on your front door to explain, to petition their government, or you expect them to come into your office here or send you an email or call you? It's how should they be contacting us if they're giving out our personal addresses? It might be to, send an angry mob to intimidate us. I mean, we've seen that happen. So there is a balancing act. I'm not sure exactly where to draw that line, and that's why we've had some difficulty with our committee.
Senator Bell?
I was like, you said it's the same one Senator Figures had?
Yes.
This session, we already passed it this session?
Yes.
Okay. Do you know that bill number? That's why I was looking.
203.
Okay. Thank you.
Senator Bell, while you're looking at that, let me make a comment. I agree with you on the intent, and so oftentimes, has been said in here before, that's the tough part, is to figure out the intent, the mens rea. But I will say that that's already an existing law as it relates to other crimes. For instance, harassment, and I should know this by now because I've said it enough, but harassment is you have to have the person commits the crime of harassment if with the intent to harass, alarm, annoy another person, he or she does the following thing. So that intent is already in law in certain statutes already. How we determine that intent is typically a fact finder, be it judge or jury, I think. So, Senator Smitham, you got a comment about that?
Those, when you shared that with me right there, you said, it's what you said, and then you said, and these other things. You remember when you just said that? I don't see other things in this bill. That's the elements I'm talking about. You telling me about them other things are the elements, that A, B, C, or D.
I understand.
You see what I mean? And here,
you're not talking about intent, how to determine intent. You're talking about what is in the statute that leads a fact finder to determine that there was intent.
That's it. Okay. And that's the whole point I'm saying here. And that needs to be tightened up in this bill right here, in my opinion,
Okay, one thing in this bill, it says, like, posting your home address, photographs of your children and the schools your children attend. So it's not just, it becomes a little more definitive throughout the bill, and it names things where.
Can you name them? Can you name the rest of them?
Okay.
Because so far, I'll just be very frank with you. I like them very too, with both children and stuff like that. I like that.
Okay, intentionally, electronically publishes, posts, or provides personal identifying information. So it would be like your children, their home addresses, your home address, which we all have an address here, or our post office box, or whatever we use for our office. But it's posting your personal information and your family's personal information to allow the potential for harm.
Is it limited to that, or what else does it?
No, this is included in the bill.
But I know, no, I'm talking about in those things you just told me. Okay, I like those. All right, now what other ones though?
Okay.
You see?
Let me look through here. Okay, it doesn't list anything else. It just talks about your personal information, your family's personal information, and this is included for like firefighters, law enforcement, not just elected officials.
Well, no, I think they need to be included because we had a firefighter to be killed up there, at the fire station, standing outside of the fire station. Of course, they caught the guy. Thank God. It took us about almost a year, remember that, but we caught him, but I think, I could support it, for instance, if it's for that purpose, what you just said. But if it's some catch-all to, once again, leave subjectiveness just to an officer to come up to determine it, that's not subjectiveness, that's objectiveness. It's sitting right there. These are the elements. If it's limited to those elements, that's why I said if you would list all of them, I could hear them.
Right.
If it listed to those, then I could work with that, Okay. But if it's a catch-all at the end, then I got a problem with that because it doesn't define what it is,
Right.
So I just want to share that, and I would probably, who's the analyst in here for Judiciary? One of y'all, the lawyers. Okay, I need you to check that out for me. I know if you wasn't listening close, with the elements in there. She mentioned some of them, but if there's some more and it's a catch-all, I'd like to know that, so that I could get with you, or you, since you the Senate sponsor, I can get with you and. Oh.
Senator Figures.
Okay, I can get with her.
Okay.
And and then we can do that. Okay.
All right, thank you.
Senator Coleman Madison.
Thank you, sir. The concern I have with this is that people put a lot of stuff on Facebook. They post pictures of their kids. They post pictures of their kids at school and activities. So what's to prevent someone from copying a picture from that and reposting it? I think that's where we're talking about. It's a great idea, and Senator Figures explained it from the stalking standpoint, so I think we kind of focus on that. But if it had, it really needs to be more specific so that we don't inadvertently throw a big net out there and catch people who are just innocently. And if it's not, if you don't have any objective guidelines in here, if it's subjective, just the example that I gave, someone could get caught in this, and there was no intent to do harm. So that's the reason I have.
Senator Bell, then Senator Singleton.
All right, you said SB 203
Yes.
this year, her bill?
Yes.
That's the indecent exposure bill.
That's
Senator Figures indecent exposure, is what I'm looking at. That's why I was looking. I did not think we'd had a doxing in here, and that's why.
Okay.
That's why I started to look, and that's the first thing you got up and said, and that's why I was confused over here, and that's why I was asking, because we have not had a doxing bill that I can think of this year in here. And then I looked when you give me that number, and that's her indecent exposure bill.
Okay, then I was given the wrong information. I apologize.
Mr. Chair, but we carried over till next week to sort out. I think everybody here's got some questions. I asked we carried over till next week to figure that out.
That's a motion by Senator Bell, second by Senator Singleton. Any opposition using previous rule on that? All right, bill's been carried over. We'll do our best to try to get you up next week. Members, if you've got those questions, concerns, and if you would reach out to the folks that you've heard here. Well, Mike Harper does a great job for the committee, and thank you, Mike, for doing the analysis that we've got. If you will, get with Senator Smitherman and try to answer those questions he's got.
Okay, thank you.
Thank you. All right, next up, we've got HB 105, Representative Gidley. Good morning.
Good morning, Mr. Chair. Good morning, committee. Hope everybody's doing well today. This bill, HB 105, literally takes current law and increases that law to add the term grooming concerning those that would want to entice children into sexual exploitation. I worked very closely with the Office of Protective Services on this bill to add some things, especially electronic communications that can be used to entice, groom, or help prepare children to go into sexual exploitation or sex trafficking. So on that, that's a general explanation. If you have questions or need more details, be glad to give that to you.
Got it first by Senator Bell, second by Senator Smitherman, Senator Gavan. Senator Smitherman, you got questions or comments?
I do have a question. And I agree with your bill, and I'm gonna, support your bill. My concern is this, is that, and I'm kind of talking to, right now, I think I'm talking more to the chairman and to the senator from St. Clair County. Let me look around, because y'all do criminal stuff. You see what I mean? So maybe I'm missing somebody in here to do it.
Well, I was going to say, let's clarify that.
Y'all do criminal law, and in this, where does it come in when I give you an example. Nothing. I'm just giving examples. There are, and you know it. We know it because we do some criminal stuff from time to time. I do from time to time, and I was the clerk in criminal court for Judge Pete Johnson, who created drug court. So I had to say that for 2.5 years. So, what happens in these situations where a person goes on an adult site, they have these app sites, that deals with this stuff. All right, and it's an adult site, and then as they're communicating to an adult at the end or whatever they do, all of a sudden it comes up and somebody said, "I'm 16." Okay, you understand what I'm trying to
Yes,
say
sir.
now? I mean, what does this do in that regard? Because the person went on dealing with adults. Okay, that's the way it was presented. That's the way all this, that whatever communication they do. Now you get into this end. Oh, by the way, no, I'm not an adult. I mean, what did you see what I'm getting at now?
Yes, sir, I understand.
They landing right where this bill is now.
Yes, sir.
Okay.
Exactly.
Okay.
Exactly.
Now, does this bill addresses what I just said?
Let me,
Because that's an element close to entrapment.
Senator Smoothman, one of our legal experts here may have an answer to
I
that
don't know
question.
if I'd go that far. I have not seen a case yet that it's not very, very specific, the age. Most of the time, the child even tells them the age they are on cases that are made by law enforcement. There has to be some correlation there to the age. Usually, it'll be in the text message or something, or the individual knows them, whether they're a church member, whether they're somehow connected. On most of the cases, or all the cases I've seen with this, it was very specific on the age.
Let me ask you this question, man.
Yes, sir. Yeah.
What happens in those cases where it's a sting and it ain't no child? You know where I'm coming from with it. It ain't no child. They dealing with an adult, and now all of a sudden you got law enforcement on a sting on the other end, and it never was a child.
Where the adults holding themselves out to be a child.
Yeah. I mean, that's.
I think under that we're saving a child from being sexually abused. I mean, the person shouldn't. If the person thinks they're communicating with a child,
They start out, they think they're communicating with an adult.
right? But in those stings, the ones I've seen, they know at some point they either use a child as bait at the house, and the person comes in and brings pizza, brings beer, brings condoms, brings things to the house. I know Blount County had some stings they did, and every sting they did up there, it was no ifs, ands, or buts that they knew they understood they were communicating with a child on those. And I think in those, I think we're lucky that some child did not get abused because the adult's intent was to abuse a child.
The last question to that, and I agree with what you said. Last question, though, is that they don't never make contact with this person.
Correct.
The sting, whoever this is, in the end, that comes that way, and this never happens.
I agree, but when most of those, you have the adults sending pictures to who they think's the child, and I think we're lucky that some child's not getting sexually abused on it because the adult has the intent to mess with a child.
I agree with you. Thank you. I just want to know what path this carried, and I appreciate you sharing that with me. Thank you.
Senator Albritton and Senator Coleman Madison.
We're doing a lot of these bills for protecting children, and I support that concept. But sometimes we have a tendency of creating instances that we throw the net too broadly. I have concerns with some definitions here. When we're talking about grooming, and the definition is means to engage in a pattern of behavior that seeks to prepare, induce, or persuade a child. That's the role of a parent. That's the role of a teacher. That's the role of the church. That's the role of anything that you're dealing with a child is to be preparing and teaching, persuading. I think that this definition could unintentionally throw a net over people and would have a chilling effect on who and where people could interact with a child in any forum, electronically or any other way, phone calls and such. I'm concerned about where we're headed as a society because of where our society is. But this seems to be a law that is will have consequences beyond what we can imagine. Maybe I'm overstating it, but I think we need to be very, very careful about where we head with some of this stuff.
Well, thank you, Mr. Albright. Can I address that, if I may? And I appreciate your comments very much, and I appreciate your concern there, and I understand that fully, and surely empathize with that. I think the idea here is not those normal functions that we do as parents, as Sunday school teachers, as a pastor myself, interacting with children and different things and other things. I think the idea here, as you read the entirety of the bill, is what the end result is, what the purpose is, not those normal things we do in the course of a day, and we interact with those things. But what is the intent of that, and what is the end result of that? And I think that's what we have to really focus on here.
Then we get back to the intent and the result. I understand that. But I support the concept.
Yes,
I just have some very major concerns about how this may affect us.
Yes, sir. And I appreciate those concerns.
Mr. Chairman.
Senator Coleman Madison, I think, and then Senator Smitherman.
Thank you, sir. I agree with Senator Albright. It should be something added on to this at the end of that, for the purpose of, again, sexual solicitation or engagement or whatever. It kind of stops. I mean, you list other things of what their activities, but you don't say for what purpose. And so I'm going to be asking for an amendment for this purpose. But I just want to make a comment to our committee. I mean, everybody around this table is an attorney or a legal background, maybe exception of 3 of us, because who knows about Elliot. But I don't know if we are actually paying attention to the laws that we pass or bills that we pass. You know, I was one of the few people that was opposed to the sexual education bill. Not that I'm opposed, that it didn't have merits. The fact of the matter is that this is what I was trying to avoid, is the fact that the grooming of young children, or the grooming of a child who doesn't know. So here we are. This is a great bill. I like the concept of it. Mm-hmm. But then we pass something that says, but we don't want to educate you about, you know, the real facts. And if they don't know, this is what they'll fall into.
Yes, ma'am. Well, Senator, can I take you back, if I may, to, I believe, line 64 in the bill? If you go back to line 64, it says, a person commits the crime of enticing a child for immoral purposes if, with lascivious intent, he or she entices, allures, persuades, grooms, or invites, or attempts to entice, allure, persuade, groom, or invite any child under 16 years of age to enter a vehicle, room, home office, or other place for any of the following reasons: for the purpose of proposing the child performance of any of the following. Then it lists things here: sexual offense pursuant to certain section, sexual conduct pursuant to a certain section, a sexual performance, genital mutilation, to commit any of the following: a sexual offense pursuant to section 1520A-5 against the child. And it goes on to list several other things. So I think we have spelled out in that bill, I know you mentioned bringing an amendment, but I think if you look back there, you'll see that it's spelled out what that intent would be in this bill. Yes, ma'am.
I understand. It's just that you need to include that under grooming, because the definition of grooming, going back to Senator Albright's statement, is that could be misinterpreted as far as a function of, you're right, parents, teacher, coach, whatever. And if this is your definition of grooming, someone could take this and say, well, the coach was doing X, Y, Z. Well, that's the definition of grooming in here. But you are really trying to get at all those things that you just named with the intent. And that's why that needs to be included in here.
Senator Coleman Madison, I think Senator Gavan's got something to say that may address some of the concerns.
You want me to yield then?
I'm sorry.
I yield
to the co-chair.
Yeah, I yield.
He may answer your question too, your concern.
So first of all, I would say not what I asked for a recognition for, but as far as that grooming definition, all it does is throw back to this line 68 and explain what that word means. It is not a crime in and of itself, okay? It throws back to line 68 to help the court understand what that and help the prosecutor's office understand what that is. And then we very specific, I say I didn't draft the bill, but it's very specific in what you've got to do. You've got to be doing it for one of these improper purposes, which he's very specific about. I think, and I'd be willing to do this on the floor if it pleases the group, but I think if we put in somewhere on line 68, specifically to engage in prohibited conduct, if that made people, I think it already addresses it, but if that alleviates some concerns, then I think we could proceed that way.
Mr. Chair, if I may. I need to address this one particular thing, if I may.
You yield. I will yield to the budget chair.
Well said.
When two Republicans argue, don't get in the middle.
You know my philosophy.
I graciously disagree with my learned colleague. Look, this can't be read together. This can't be read together. They're separate. And the reason they're separate is because they're different penalties. In the first part of it, you've got the actuality of enticing into a room and whatever to do this stuff. That's a Class C felony. But when you get to the grooming and the electronic enticing, that's different because it's a Class B felony. It's more serious to do this electronically than it is to do it in real life. That doesn't make any sense to me. And I'm not sure how you can read them together when they are completely separate of penalties there. So we need to clean that up in any way. But and we're reading this in a vacuum. When you read, by that I mean, when you look at this in real life and all the other law that comes into effect and such, and you look at the potentiality, especially the destruction that may happen in domestic matters, where everything that's used that comes into play is used with great passion in the courts with matters like this and domestic matters, and DHR gets caught up in it, and everything else gets caught up in it. We just need to be very careful about how we're extending and expanding these matters like this. Now, again, it's just a word of caution.
Senator Smithman?
First, I'm going back to his first statement he made, and that's what my light was on in relationship to him. You are right about the chilling effect. You're right about the chilling. You are. I coach, and I've been coaching 45 years, and I can tell you 45 years ago, you could grab a player by the hand, and say, look, come on, let's go play. Or you could pat him on the shoulder or whatever, say, come on, man, let's go out there and do what we got to do. Now you raise your little voice at them. Just raise your voice. That's how we don't come from that point to that point. It's a chilling effect. You know what yeah, you're right. And even with what you do in punishing kids now, you could make them run the stadium seats so many times and be warm out there and do that. Now you do that, that's cruel and unusual. So now you just got to sit them on the bench and give them some tweezers to pick them splinters out their hips because they ain't going to get up. So it's just a different approach you got to take. And so what you were saying, it is a chilling effect. And you're right about the inconsistencies of the sentencing because Judge Pryor and knock on wood, myself, I was sitting in your seat as chairman of Judiciary, and we worked together to create the Sentencing Commission. He and I we worked on it for almost 6 months. We created for the purpose to have consistent sentencing, whatever that might be. And he touched right on the fact that we've deviated from that now, and now you got all this, you got this and you got this sentencing. So yes, that needs to be cleaned up, and I think those definitions need to be addressed too. Thank you, Mr. Chairman.
Thank you. So we've got a first and a second. Before we, if there's no other discussion, before we vote on the bill, I just want to say, listen, I don't think there's a person in this room on this committee that doesn't agree with the intent of what he's trying to accomplish. But the reason I like lawyers and Senate Judiciary Committee, even those who aren't lawyers on here, is that we have, meaningful conversations as it relates to what the bill does, what impacts it could have, both good and bad, and I think that's a good thing. So with that being said, any opposition using previous rule, get this bill out of committee. Senator Albritton will be a no on that. Senator Coleman Madison would abstain. I would just urge you, the questions, the concerns you've heard here today, to tighten that up to make sure there's no adverse consequences to those who are simply going about their business, as Senator Smitherman said, either in coaching, whatever it may be, that we try to address that, get it right before we get it on the floor. All right, Bill's given a favorable report. Thank you so much.
Thank you. Thank you, committee. Thank you, Chairman.
All right, next and last up is HB 11. Representative Pettis, third time's the charm.
I hope so. This is the youthful offender bill, and I think we have an amendment.
I'm sorry. Yes, members of amendments in your packet. You got me tickled a little bit. I've got the amendment in the packet, and I'm gonna offer that amendment. Representative, you got a first and a second on the amendment. Any opposition using previous roles? Senator Coleman Madison. It takes it down to where a youthful offender, the bill itself, but this even is, so we passed it last year out of this committee, but this is even, I don't want to say watered down, but it's
Tighter.
a little tighter. This only would apply to capital murder. It would not apply to any felony murder or anything along those lines. So in other words, if you, any charge that you get other than capital murder, this piece of legislation would not apply to it. And this legislation, if it's capital murder, and if those charges are reduced at some point, then that individual would be eligible for that youthful offender status. That's something we put on there last year that you've incorporated this year. So on the amendment itself, did you want to speak on the amendment? Or all right, got a motion for adoption of the amendment by Senator Van, second by Senator Bell. Any opposition using previous role on the amendment? Both ayes for Senator Coleman Madison and Senator Albritton. Now we're on the bill as adopted, amended. Senator Smitherman.
Thank you, Mr. Chairman. I'm right back where I was from the beginning of this whole issue, and it's simply this. I'll make another reference to coaching, and I've said this, probably some of y'all may have heard it, and whether it's in here or private conversation I've had. You got a situation I haven't seen the murder part, but I've seen crime committed I've seen crimes, but I've had information. We had basketball practice. Your kids up at the people up at the coming up there. This person needs a ride home. They leave practice, get in the car. They go into the neighborhood so they can be let out. They know these boys. They live in the same neighborhood. It's unfortunate, but they live in the same neighborhood. This person decides to stop. They're gonna go into the grocery store, get something, Quick Mart. They ain't got no money, and they know they don't have no money. So they going in there, they gonna steal it. They get it. They coming out, the person comes out, dresses them. Yes, it's unfortunate in the world we in now. Folks don't do what we used to do. That's fist fight. Ain't nobody gonna let you touch them. They'll pull out a gun. Capital murder. In the commission of a robbery, and they kill, theft or whatever, and stealing, and they kill someone. What we saying, once again, is that child who just got in that car, who left basketball practice, who's still sitting in this car, and these persons are gone in there to do what they're doing, they going to charge him with capital murder. They going to charge him. I heard all this stuff about, they charge him, and then later on they reduce. It's what you've heard me say before. Mm-hmm. If the child is the wrong one, he don't get the benefit of the doubt. Okay, so now he charged, and he's facing the same thing that this person is facing. As I said before, the person who went in there, if two of them went in there, then those two okay? Because they going in there and they'll be a part of it, especially if they have knowledge. And they know that through interrogation. You know, they get them back there in the rooms and they say, did you know A, B, C, or D? And if they know, they'll get it out of them. So that's my concern. We got innocent kids who's going to be pulled up in this net, you know, under this situation that didn't have nothing to do with it. Knowledge-wise, nothing but just being in the car. Didn't even get out of anything. I got a major problem with that, and that's my major problem. You and I have talked.
Yes, sir.
That's my major problem with this bill. It just well, that net y'all were talking about, it's just gonna scoop up everybody who was around it, even, you know, in that net, and that's not right. You know what I mean, to take somebody who's innocent, because they ain't gonna have the money to get no big time lawyer. They're gonna be subject to public defending. The public defenders got 300 clients by themselves that all they got time to do is work out a plea for somebody. They don't even have time to try them. They had too many cases. And so I just have problems with this, and that's the reason that under this form, I can't support it, you know, like under this form.
Senator Coleman Madison.
Thanks, sir. This is a rather sensitive issue because I have a family member that's caught up in the same situation. In the car, somebody committed a crime, but you all together, all charged the same, and so you're sitting there basically on a murder charge. But did we not pass something to deal with that as far as discretion or the judges? I thought we had, and it wasn't a couple of meetings ago that we dealt with something, did we not? I'm trying to connect the dots with the bills that we passed.
Senator, he may have an answer to you.
Well, I know we had some discussion about the fact that the DA had the discretion to charge them or not to charge them, or I guess to reduce the charge or whatever like that. I think I remember that, you know, in that realm that we had that conversation, because I think Representative kind of said that in his communications with us individually about the fact that whether the DA, you know, he gave me some rationale behind it. I won't say it here about that, but yes, that's the conversation I recall, that addressing what you just said about the DA itself.
I just want us to be very clear, because once we put something in the law, and we've gotten ourselves painted into a corner about this in the past, unintentional end results. We make laws, but we don't really interpret the law. When it goes to the judge and is before the judge, they interpret our intent. It may not be that. And so the concern is that when we pass a law like this and we don't try to look down the road at unintended consequences, or how can we prevent this from innocent people getting caught up in it, or is there a caveat or some way to make an exception where you do ask those questions, you find out, okay, were you in the store, or were you a part of this, or did you have the weapon? Where were you when the crime was committed? And we do have situations where people are aware of what is going on. You may be in the car, but you may be driving the getaway driver. So you are guilty as far as playing a role in that. I don't see that in this. And so that's the concern that I have. It doesn't say anything about the discretion that the judge may have or whatever, unless I'm missing something.
Well, the way it's explained to me,
No, go ahead.
the way it's explained to
Address
me,
that, and then we're going to go to Senator Singleton and Senator Smith.
the district attorney says they have to be indicted for capital murder. And based on their investigation, all that, they'll decide. I know we talked about the shooter. Their intent is to get the shooter. They cannot always do that because the other ones won't tell on each other. But their intent is to get the one that actually pulled the trigger. But we cannot put it in there just because you don't always know that. But right now, the DAs and all that, they still have the discretion to take it to a grand jury, decide if it's capital murder or if it's not. And like we said, if they charge them and then it's not indicted, they get a lesser offense, then they would still be eligible for the YO.
Senator Singleton.
I guess my question is procedurally. at what point in time does the defense attorney file for YO for his client? Is it at the time that they're charged? Because you could charge me with murder, get an indictment, and then do an enhancement to capital murder at that point. At what point, and I think it's going to be upon that attorney to, at least in most of those cases, to always file that YO, regardless to when he's charged. And so I think that we're saying, do you charge it when he get charged? Because it may be just simple murder when they look at it in terms of the first investigation. Then it goes into a capital murder. Then you're saying at that point in time, hopefully that they may have sorted it out at that time who may be. But I see Senator Smitherman a lot of times, if they can't sort it out, then everybody's charged with that capital offense. So there's no YO for anyone at that point in time, if it's 5 of them.
So I'd say, maybe I'm mistaken this, but I the appropriate time is to file on a felony case is not at the time of the arrest, but YO application at the circuit court level for the circuit judge to determine. Senator Smithman?
Actually, in Jefferson County, you can file at district court.
Can you go back and do it both? Can you ask for a rehearing on that in circuit if they get indicted?
No. Well, let me say this. No, what I was saying, the filing verb, I was addressing that.
Yeah.
The problem, Senator, is that the when it gets to district court, it's already capital murder. So we are saying here, what we are saying in this bill is that basically they're gonna charge everybody capital murder, okay? And once they charge them with capital murder, then when it gets to district court, because we passed this bill, they automatically are denied without even applying, because the bill says that if you're charged, not found guilty, not coming off the grand jury or anything, if you're charged by the DA, at that point, you cannot have any consideration under these criminal elements here for YO, okay? And so you're at a situation where, and it's unfortunate, but it's the truth. You're in a situation where a 16-year-old is in there and they being interrogated. They don't have no lawyer there, and you can read Miranda rights all you want. They don't even know what Miranda means, and you in there and they looking at capital murder. Then yes, I don't know what happened in there, but that's what the DA wants. They want everybody to be charged with capital murder. They want to interrogate them, and then when they interrogate them, they after the interrogation they saying then they can reduce the charge. Okay, that's what they want to set up. But if the person don't talk, whether they were in the car or not, they ain't lifting that up off of them. They're going to move from that point all the way through that process with that capital murder, not being able to apply the YO or anything. The purpose, what I don't like about it, it takes out the discretion of the judge where you get a YO. You just wipe that out. The judge has nothing to do with it anymore. And I can just tell you this, and I feel comfortable telling you this, and I'll accept if I'm 1 or 2 wrong. But over the last, 5 or 6 years, it ain't a judge in Jefferson County that done gave him YO. That everybody's been denied when those facts show that everybody has been denied. I mean, I checked on that myself, and I may be wrong going back 5, 6 years, maybe 6, 7 years. I don't have that accurate. But judge is not going to give it to them. I don't care where it is. I don't care who the judge. I don't care what it is. They are not going to give them somebody that shot somebody some YO. Okay, that don't happen. And I don't think as a DA out of Jefferson County can get up and say in the last 3 or 4 years that anybody has gotten it. So my whole point is, I don't want that person again in that car, and I'm going to be short with this part, that had nothing to do with going in there, pulling that trigger, shooting somebody, to be thrown in that kind of situation and looking up pleading to capital murder because they're just charged and
as an accessory.
Yeah, that's all.
Senator Bell, and then I'll entertain some motion.
I want to go back and follow up something the learned Senator Smitherman over there knows. talk about judicial discretion, it also comes into attorney discretion. You better know your judges. Some judges may be a little more favorable to WIO than others, so you may want to hold it at times and get on up to that circuit level and know that. But I think we have over time tied judges' hands to a certain degree, and that's the one thing that all facts of all cases are not the same. A judge should have discretion to be able to judge the facts on each case different from the other.
All right, entertain motions. I'll move for favorable. Second by Senator Gavan. Understanding there was a lot of discussion here, let's call a long roll.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton? Senator Smitherman? Senator Stutz? Senator Weaver? Senator Barfoot?
Aye.
5 in favorable.
All right.
5, 3, and 1.
All right. Bill's given favor report. I would just echo the concerns that were voiced by Senator Smitherman. You heard some other ones here. That individual in that situation who is not the trigger puller, who is in the car, I think in most people's minds should be treated entirely differently than the one who pulled the trigger. So I'd ask you to continue to work on that before it ever makes its way to the floor. Senator Elliott?
Mr. Chairman, one brief comment, and it's not necessarily about this particular piece of legislation, but I did notice it on the analyst report, and I think it's important to point it out. It says this bill is virtually identical to SB 25, sponsored by Senator Weaver. Our analyst does a good job letting us know if a bill is virtually identical to another bill, and I just think that's something we ought to look at.
Yep. Thank you. We hadn't had her bill up yet, but you're exactly right. Mike does a great job for the committee, and thank you for all you do, Mike. All right. Any other business to attend to? Seeing none, we are adjourned.
Thank y'all.